Well, it seemed that these witnesses called by the prosecution did more for the defense than they did for the prosecution. They really did not support any theory that the defendant, Kit, left the home. But keep in mind, he's not charged with murder for actually committing this murder himself. Under Kentucky law, he's charged with complicity. And in order for the government to prove complicity, they don't need to prove that he left the home and killed these three people himself. All they need to prove is that he acted in concert with others somehow. And so someone else could have killed them while he's still in the home. Clearly, they'll need to establish the facts necessary to get there, but I don't think that it's that devastating a blow if the facts show that he never left the home.
Ed Bull, if you're not sure if you left the home or not, why bring these three up to basically ensure the jurors don't think he left the home because of the fact that the front door doesn't open and there's video surveillance on the back door?
I'm completely confused by what the state was attempting to accomplish this morning. It's almost like they decided to take a brief break and let the defense call three witnesses that bolstered their case. It looked like at times perhaps they hadn't prepped these witnesses in any way, and it's clear after the fact that they were completely adverse to the state's position. I understand my colleague's approach that they don't have to prove he committed the actual homicide, but he acted in concert and complicity with another. But even these three witnesses don't advance that claim, and I'm not certain why you would. If you recognize, hey, the defense is going to call them if we don't, at least as a state, you can then argue there's some type of bias. Look, the defense called them, of course, they're his family, they care about him. But when you call them as the state and the defense gets to flip them, as all three witnesses were just flipped in front of this jury, I'm not certain why you chose to start your day where the jurors are their most fresh by putting on three witnesses that did nothing to advance your case in any way.
Florina, would you, if you don't bring them up, the defense is going to bring them up. Is that why you think that the state decided to use these three? Because to your point, if, fine, the complicity is on the table and they don't have to prove that he left the house, but what they were trying to accomplish there was something that wasn't there. It wasn't in those original police interviews, obviously. They wanted somehow for one of these three to say, yeah, you know, now that I think about it, I think Kit left in the middle of the night. It wasn't going to happen.
Well, you know, the difficult thing with being on the prosecution side is witness prep is not something that prosecutors do all that well, right? You don't want to tell the witnesses what to say. You want them to tell the truth. The problem with the truth is those facts may not necessarily be favorable to your side, and you're stuck with it. When I was a prosecutor and I would prep witnesses, I would never tell them what to say or how to say it, except to tell the truth and be honest. The problem here is I think the prosecutors miscalculated just how useless these witnesses would be for their side, and they really didn't parse out those facts in any meaningful way to aid their complicity theory at the minimum. And so I understand why they were called. I would absolutely call them because I would not want the defense to call them and then say to the jury, here's what the government didn't tell you, or let's hear from people that the government didn't want you to hear from. But when you make that calculated decision to call them, you need to work with the facts to highlight at least something that works with your theory. And here, like my colleague just said, it really sounds like they took a break and put on some defense witnesses.
Yeah, and I think it's safe to say that they didn't know about the lack of opening in that other door because it seemed to come back to bite them. All three witnesses talked about that door not opening. Here's Austin Spencer, 23-year-old, saying, yeah, you can't open it.
We talked about how it was an old house, right? And which door was the main door that you used?
The back door that leads to the backyard.
Okay. Why is that?
The front door of the house was, my understanding, broken. I was never able to open it.
But now explain that. Explain that to me.
Sure. So the front door of the house, I don't know what had happened. It was just jammed shut. Even if I tried to budge it, pull it, turn the handle, wouldn't open. I don't know if the door was just had fused into the door frame or something, but
So
couldn't open it.
when you moved in 2013, did that door function, the front door, did it function like a normal door?
No.
When you were moving out, did that door function like a normal door?
Not that I recall. I don't think I've ever seen that door open since I had lived there.
Ed Bull, in openings, the jury was told that there was video surveillance on the back door and that Kit Martin would have had to have used the front door because he wasn't on the video surveillance, and they wish they did have video surveillance of the front door, but that's the door he used. He used it to go kill those 3 people and do it while his family didn't notice. Clearly, they didn't know about this situation with the front door. How devastating is it to the case, and is that something they should have known?
Well, they would have had to have known it. You just heard Ms. Spencer testify about the, as she described it, assault on her as law enforcement's approaching the back with rifles drawn, as she's calling the police, because she thinks her home's being invaded. Law enforcement searched this home. They clearly know, whether or not the front door opens or not. So perhaps the issue is law enforcement now is going to testify that, in fact, the front door does open. Because if that's not what they're going to testify to, this testimony becomes even worse for the state. If, in fact, you're going to have a cop now come on the stand and say the law that we were able to open the front door, you can do it. Maybe it's a little tricky, but if you do this, the door opens. Now, the state's reason for putting these 3 witnesses on makes a lot more sense because you discredit them. But the reality is, and I think Ms. Spencer's last comment of we had the rear videotape, law enforcement never came and got it, is also very important from this case, because you're right, Ted. If their whole theory is he exited the front door and you can't exit the front door, that's a problem. But it also goes back to their theory isn't he committed the homicide. So I'm not certain why, by that I mean he wasn't the actor who pulled the trigger. He acted in complicity. So where is the evidence of his cell phone records? Where is the evidence of who else is the other person who committed this offense? Because at this point, they're presenting a case as if he was the shooter, although their theory is he was not the shooter. So at this point, I think you're right, Ted. If that front door doesn't open, and law enforcement has to know whether or not that door opens or not, because they executed a search warrant on that home. So it'll be fascinating to see whether or not this was a strategic move by the prosecution to discredit these witnesses, or if this was just a colossal blunder.
Well, we will find out as the case proceeds. We're going to step aside, take a break. Much more when we return. Stay with us.
Now more than ever, with a dual complete plan, you could have a wide choice of doctors to choose from, a $0 copay for prescription drug coverage, credits for health items and healthy food, more dental coverage too, all at no extra cost. You have Medicare. You have Medicaid. You may be eligible for dual complete. So call the number on your screen now to see if you're eligible or to enroll in a dual complete plan from United Healthcare.
Welcome back to Court TV Live on our continuing coverage of the Commonwealth of Kentucky versus Christian Kit Martin. He is facing triple murder charges. And to this point, the state, the Commonwealth of Kentucky has put on several witnesses. This morning, we had 3 family members of the defendants, stepchildren and the fiance of the defendant. And they all came in and basically gave the jury a look at the defendant's life prior to the triple murders in his neighborhood. And now we're wondering, where are they going to go next? Well, let's bring in the people that know how these cases are constructed, because they've both either been prosecutors or are a prosecutor. Ed Bull is a prosecutor in the state of Iowa, Florina Altschiller in New York, former prosecutor, criminal defense attorney. So they've constructed this case sort of the way you would expect with the investigators. And then this hiccup today. Where do you think we're going? Because we still have some compelling testimony we're expecting, Florina, in that there were several people that came out of the woodwork afterwards and said, oh, if anything happened, my friend said, if anything happened to me, point the finger at Kit. They were fearful that the Calvin Phillips, Pamela Phillips were both very scared at the potential of possibly being harmed by the defendants, and they told other people. The judge ruled in a pretrial hearing they could come in. We've heard from a couple, Major Garrett, but we still have a few more. Is that the crux of the state's argument? Because in the opening, it sure was, Florina, is motive, motive, motive. I don't know if we've gotten there yet, but a few more of those witnesses might help.
Look, motive is interesting. Juries love to hear the motive, but motive is not even an element of the crime. Motive does not, beyond a reasonable doubt, prove each and every element of the crime. And so far, I don't see any of the elements being established. If they're going to rely on motive, that may resonate with a jury. But ultimately, when the jury gets those jury instructions and gets the verdict sheet, they're going to need to look at facts that were established at trial that line up with the elements of complicity. And it seems that the prosecution is more like defense attorneys, really shooting out into random areas, kind of. And that's not what the prosecution should be doing. What the prosecution should be doing is have a very clear narrative with facts that match elements. And they're not there. They're saying, oh, he did it, he left the house. No, he didn't do it. He acted in concert with others. That being said, we're still early on in the trial, and we'll see what happens with their other witnesses. Maybe they'll get there. Maybe they won't.
Ed, does hearing from the Major Garrett yesterday and others that the victims were fearful of the defendant important? And does it carry a lot of weight? I would think so.
I agree with Florina. I mean, quite frankly, the jury's going to be read the instructions. And so they're going to go back into the jury room and say, how do we meet each one of these elements to prove murder in the first degree times 3? And at this point, they're not there. Now, I agree, we're early on. There may be additional witnesses. We haven't heard any of the forensics, any of the science that's involved. But whenever, as a prosecutor, I've used the theme, motive, means, and opportunity, my fear is those 3 things can be true, and I can still not come anywhere close to meeting my burden of proof beyond a reasonable doubt, because motive, means, and opportunity can all exist, but it doesn't mean you actually committed the offense. And I would assume that's going to be the type of flip we're going to see on the defense of, you can have motive. Most people, especially a military man, probably has the means that they own a firearm. An opportunity, anyone can have an opportunity to commit an offense. That's a far afield from actually committing the offense, either in principle or by complicity. And at this point, we've seen a lot of fluff, but we haven't gotten anywhere near. And Ted, to your specific question of people were fearful, my question comes into play is, who was telling these people to be fearful? Is there the possibility it's the ex-wife who has a bone to pick with this defendant? And so it'll be interesting to see. It's one thing for these people to say, hey, if something happens to me, look to this person. That may be true. You should look at those people, because they have the motive and means and opportunity, but it doesn't mean they actually committed the offense.
Florina, Joan Harmon brought up again today. Her name was brought up in front of the jury today. We found out that she will not be taking the stand because the judge has agreed to quash the subpoenas for her and her son. But she is that empty chair defense, right? She's the one that they're pointing at, and she seems to be making her way into this trial from the openings and through several of these witnesses. Big point today for the defense, getting one of the witnesses to blurt out that she was scared that Joan Harmon was going to kill her.
Yeah, what the defense can do is throw different things up at the wall and see what sticks, right? The defense doesn't need to prove anything beyond a reasonable doubt. What the defense needs to do is just raise doubts. And the defense can raise multiple doubts. The defense can have, unlike the prosecution, multiple theories. And so long as the jury thinks, oh, hey, this one theory is questionable and raises doubt, that equals a not guilty conviction. So this ex-wife is a very good other suspect who also had motive. And implicating her is an excellent defense strategy.
Yeah, looks like everybody is back in court after the mid-morning break.